Right.
Hi, Mark Duffy and Paula Bushelman. Nice to meet you.
All right, it's 7 o'clock, so we'll get going here. I believe the first thing is a roll call. So we have Mr. John McVeigh.
Present.
Mr. Eric Rolfe.
Present.
And myself, Bob Whalen, present. And I believe that is it for the board. I know George is not going to be here today, so we do have a quorum. In front of you guys, you should have the minutes from last month's meeting. I don't know if you've had a chance to review them.
Yes.
And once you've had a chance, I will take a motion if you agree to approve or have any recommendations, changes, et cetera.
I approve.
Make a motion.
I make a motion to approve.
Second? All in
Aye.
favor?
Aye.
Opposed? So be it. I don't think we have, there's no postponement of any scheduled business. For the public hearing, we don't have anything on the agenda today. I'm looking at, yeah, so we don't need to open any public hearing. I think we're here, it was more of a for formal training of how these meetings should flow since we've had a change on the board ourselves. So who from PDS? You're up. You have the floor.
Sure, and Mr. Chairman, just before Pamela gets started, so not only have there been changes on the board, but having PDS be in the role of supporting the board is also a relatively new function as well. We've been doing this for just over a year, maybe, so it's really a new thing for us as well. And when we took over the administration of the board, we never really had the opportunity to actually sit down and kind of talk about what your expectations are, what our expectations are, who does what, that kind of thing. And so now that we've been doing this for a couple of months and we saw that there were no items on this month's agenda, we figured that this would be a really good time to have a discussion, and you all can ask us questions and we'll be happy to answer those. There will be two presentations. Pamela will be going first, but we really want this to be more of like a discussion. So, I mean, we'll be happy to go on, but if you have a question, feel free to just interrupt us and ask your question. With that being said, I'll turn it over to Ms. Bushman.
Sorry, Jim's going to yell at me. My name's Pamela Bushelman. I'm the Senior Secretary for Planning and Zoning at PDS, and I handle right now all of your statutory administrative duties. So I brought along a little presentation here to help you understand. So tonight we're going to talk about the Boards of Adjustment in Kenton County, PDS admin support and the Kenton County Boards of Adjustment, KRS 100 requirements and the KDLA retention schedule, and continuing education support. So the Boards of Adjustment in Kenton County consist of the Joint Board of Adjustment, of course, other contracted local boards of adjustment, and locally maintained boards of adjustment. And the City of Erlanger is a contracted local board of adjustment, which means you handle your board, but we provide staff services for you. So administrative, statutory, along with our planner. So KRS 100, 217 through 271, that provides the statutory administrative requirements for the boards, and we provide administrative staff to support the needs of those requirements. So my administrative support to your board consists of, we schedule a BOA pre-application meeting. With all of our applicants, we process applications and payments. We send a meeting invitation, the preliminary. We send and have published statutory public notice. We have a statutory notification mail and email. We provide a certified statement of notification, a staff report with attachments and that are mailed and emailed, an action letter mailing and email, and we file the CLUR as needed. So starting with the BOA pre-application meetings, I schedule those. They typically take an hour. They're offered to our applicants free of charge to review their request, their submission materials, and make sure that they have everything together to submit to the board. It's proven to be very, very helpful. We've had people that have realized that they don't need to come to the board for what they want, and we've had applicants who've come for a pre-app meeting only to discover that they may need more than just a variance. They may need 3 variances. So they're very, very helpful. So we take care of the scheduling for that. We process your applications and payments. Those come through GovBuilt now. We send out the preliminary meeting invitation. So you members will see where I'll put the information about your next board meeting. I'll usually attach the documents for you and send it off and just ask you to please confirm with me. So I send the preliminary meeting invitation. If I can't confirm the quorum from everybody that responds to me, then I will go to your admin and ask them to follow up and find another day that we can schedule a special meeting. However, you have to keep in mind when you're doing that if you have an appeal, they must be heard within 30 days of submission. So you're already at roughly 30 days when they submit, if they submit on the deadline. So you just have to be aware of that. So we also provide statutory public notice, which is also known as the legal ad. It's provided through KRS 424-130, and it says that it cannot be published less than 7 days or more than 21 days. And some of your notices can be 1 week prior, and some of them can be 2 weeks prior. So we just historically, we send them, we have those, I'm sorry, that was the notification. This is, historically, we publish the Monday prior to the public hearing. And then we also retain the legal ad and the legal notice and affidavit, which is now published in, I didn't realize it was going to color everything. It's published now in Link, Kentucky, Link NKY. Come on. There we go. So statutory notification letters, these are required through KRS 100. This is the one. So some request notices need to be mailed 1 week prior and others 2. So to satisfy both, historically we mail them 2 weeks prior to the meeting. Go now. Oh, that went too fast. Okay. All right. So the certified statement of notification, this is not something that's required for boards of adjustment in KRS 100. This is something that we do as a courtesy. It includes the statement of notification, and it is it's filed with the adjoining property owner addresses for notification. So everybody that gets a notification letter or notification postcard, including the board, they are on that list with the addresses, and that statement of notification goes on there, and I sign it. So the staff recommendation, there's no statutory requirement for mailing staff reports, but we currently mail them out via USPS to all of the board members and the owner applicant. The board members are also currently getting from us the agenda and the meeting minutes. And then we email them to the mayor and city officials, to your council. I didn't realize this was going to color everything. I apologize for that. So the Board of Adjustment action, there's also no statutory requirement for mailing action letters. The applicant, obviously, they're there, they know what decision you made, but we do mail these via USPS to the owner and applicant, and then we email the mayor and city council of what your decision was. So for the administrative duties for the Erlanger Board of Adjustment, these are duties that you, as the board, will have to decide who is responsible and who keeps these. To maintain the bylaws, confirm a quorum, of course, as needed, prepare, post, and forward the meeting agenda, forward the meeting agenda to me so that I can put it in the packet, prepare and forward the draft meeting minutes to go in the packets. They provide public hearing support. They provide legal representation. And they maintain KDLA and KRS 100 record retention. So the KRS 100 and KDLA record retention, we maintain the project files for every Board of Adjustment case that comes in, and that includes the application and any attachments, the legal ad and affidavit, which is a permanent record, notification letter, certified statement of notification, the staff report, the action letter, any other correspondence that is received by staff prior to your public hearing, sometimes after, and the CLUR is needed. So the public items that need to be retained by the city or by your board include the agenda, the approved meeting minutes, any submitted or other exhibits, evidence, or correspondence, the sign-in sheets, and, oh, wait a minute, I'm just going to go back here real quick. Well, so when you have your minutes, when our planner comes and presents, he provides you with a copy of the staff report and the applicant's attachments, and they hand them to you. Those are considered an exhibit, and they need to be included in your meeting minutes. So your complete meeting minutes include your sign-in sheet, any exhibits such as the ones that the planners provide, and anything that anybody else brings to your meeting that you accept in as evidence. So, and that all becomes part of your minutes. And the reason that that is important is because the official record of your meeting, the permanent record of your meeting, is the meeting minutes. So that it's very important that you have all of those exhibits and attachments. It could be emails, you'd be surprised. We had somebody that brought garbage.
I was about to say that at one of our meetings for the joint board, someone brought in a bag of garbage, and they accepted that as evidence. We had to take it back to the office. Fortunately, we don't have to hang on to that. They said, take a picture of it, inventory it, you can get rid of it. But so hopefully that won't happen. But that's definitely one of the more interesting things we've had happen.
Yes.
So when things are submitted for exhibits or, at a meeting, do we have a stamp, or does the city have a stamp or something to officially date time it?
We don't use one officially for the joint board. When they accept something into evidence, obviously it's in the minutes.
Right.
The
Just saying, like,
applicant.
this is the official copy, and stamp.
Yeah, or write on it.
Okay.
You can write on it, exhibit, whatever it happens to be.
Okay.
Like Exhibit C, and then initial it and the date.
Okay.
And that can be fine. It's probably a good idea to put the case number on it as well. I would recommend that. Yeah?
So you give the minutes to me when you're done, so just make sure you put all that together with the minutes. That way, like, I have that slot for you to put them in, and then when I come in the next day, I'll get those, and then I retain them all together.
Just for me to be clear, like in the last meeting, we had all that documentation from City Johns and so forth, all the big drawings and so forth. That should be part of our minutes, of our meetings minutes.
Did he bring it in separately, or was it something that we sent, that we provided?
We all had copies sitting at our desks, but they were more than what we received in the mail and via email.
Okay.
So it was, what do you call it, the 8x11s where you unfolded. I mean, they were massive sheets.
Oh, the 11 by 17s, yeah.
Yeah.
Okay, yeah, that would be considered.
Okay.
And then typically, and you can correct me if I'm wrong, Sebastian, but typically, the chair or somebody will officially accept them as an exhibit or as evidence.
That's correct. You need to actually go ahead, and I think it's good for the record just to say what they are and actually enter them in verbally, say, I've received this from the applicant, this is what these documents are, just so then, if anyone's ever watching the video later, they know exactly what you're referring to immediately.
And obviously call it exhibit, we're doing alphabetically, right? A, B, C, D, et cetera.
Yeah, and so our minutes, I think, are a little bit different than yours. So my first exhibit that I attach to my meeting minutes are my sign-in sheet. That's my exhibit A, is my sign-in sheet. My exhibit B, 1, 2, 3, and 4 are usually the submissions provided by the planner, the ones that he hands to you. This is a copy of the staff report, the attachments and that. And then we go on from there. Now, there can be other stuff in between. That's just the way that I do it, to keep it straight.
Okay, so if I'm understanding it right, sign-in sheets, the applicant submissions, and the agenda, obviously those 3, every meeting will have it, and then any exhibits thereafter.
Right.
So at least exhibit A, B, C, every meeting.
Yeah,
Okay.
yes.
Just a quick question.
Sure.
About a month ago, we had one of the council members had an email from a resident. How would we get that into the minutes? Would that be classed as evidence, or is that just, a...
Did they show up at the meeting?
The person did not. The council member had an email from a resident saying they objected to X, Y, Z. How would we get that into the minutes, or would that not go into the minutes?
So what should happen is they should forward it either to you to be printed and read into the minutes at the meeting. Sometimes they'll forward them to us, and then we'll put them in our evidence folder. If we get them before your packets go out, we'll include any of that correspondence with your packet, with your staff report packet.
So if I get it, be safe, forward to you, or you guys forward to me, or they can forward to you directly, right?
Yes,
That's not a
either
problem.
way is fine.
Okay, because I think it was it a citizen or was it a council member?
It was Kathy Cahill who was
Okay.
concerned.
Because our previous chairman got emailed directly, and he read it and said, here is the email, and entered it as an exhibit.
Yeah, and that's perfectly fine. You can do that. You can do that, just as long as there's a trail, it went from her to you, and you got it to the meeting and read it into the minutes, or you forwarded it to us, and we got it into your packet, and it was provided to you as evidence.
Do I read the whole email when it's, or can I just say, this is what it is?
I'll let Andy
Here's
answer
a
that.
synopsis of it, or can I summarize it, or?
Andy or Sebastian?
I recommend reading the entirety, and the reason is, well, there's 2 pieces to it. You don't want some resident coming back and saying, no, you only read half of it in, and it didn't catch the meaning of what I wanted. But B, if you're going to reference it wholly, so then if anyone ever did need to look at it back, they understand the full context of it for those purposes. I can't stress enough how much I would recommend that if you receive an email like that, let's not read it into the record at a meeting. The cleanest thing you can do is forward it on and it be part of the official record.
Thank you. So I have, are there any more questions about that? I'm going to talk about the KRS 100 and KDLA record retention requirements. Okay. So KRS 100-2213 provides the requirements, the retention for the meeting minutes. It's the only record that is permanent and the official record. I know I said this before, but it is the official record of your meeting, and that's why your exhibits and your attachments are so important. You can find this at the Department of Library and Archives. Your notes that I gave you has this website on there. And you will go to the record retention requirements under local government retention schedule to find that. Permanent records are the approved meeting minutes and the legal notice and affidavit. So you keep one, I keep one. Legal notices are always permanent records, so they'll always be in our files. Yay, continuing education. Who's ready? You actually get continuing education credit for tonight, just so you know. So KRS 147A.027, and I'm sure you guys have all seen this because I send it to you. In your first, from your date of appointment, you have 4 hours of required continuing education within the first 120 days. And then 8 hours every 2 years, which is, I would think, pretty easy to get. I know you've got the House Bill 55 coming up, and that takes care of 2 years right there. So the recommended training that I have from the Key Connection that I send out quarterly, there is Board of Adjustment training on there. I think there's 3 different ones. There's one that Andy Edmondson did a few years back, but still very good, very relevant. Kentucky League of Cities came up last year, I guess. Yeah, well, 2022 came up and they did a nice presentation. And then code enforcement is actually another one that you might want to look at to see how that works. And that's just the board training. So the reporting and reports, you'll submit an orientation and training continuing education form. And at the end of my presentation, I'm going to show you how to get to this. At the Kenton County Planning Commission website. And then CE reports are sent biannually to each jurisdiction. So we'll send that to your city admin, clerk, and just let them know that you're current or you're not. Some of the things, I'm going to put this up here real quick for questions, but some of the things with continuing education, the one thing is you can do 5,000 hours in 2 years, and none of that's going to carry over to the next 2 years. So just do 8, maybe 8 1/4. But it doesn't matter how many hours you do, they're not going to carry over, and they're not going to go backward. Okay, so just keep that in mind. Any questions for me? Okay, Andy, can I walk you through how to get to so you're going to go to your server and you're going to pull up kcpcky.org. That address is on your sheet. You're going to float over the top banner and go to About. Go down to the bottom where it says Continuing Education Requirements and Forms. Go ahead and click on that. And then you'll see all the requirements from KRS and how we serve that. Click the top left blue button that says Key Connection Training Links. This is all the training that I have gathered since 2020. There's 102 hours currently. There's not a lot of Board of Adjustment specific training available, just available anywhere. So, but anything that you watch that's on this list is considered continuing education. It's acceptable. They are acceptable hours. Andy, if you click back in the center there, this is our new electronic submission form. You can just click yes. It's just telling you that you're leaving the KCPC website. We do have it electronically now. You put in your name, your email address. Andy, that's something, it doesn't matter. You select your jurisdiction, your position, and then you have the option to enter up to 4 training sessions. And at the bottom, you can also upload certificates or, a sign-in sheet if you have a picture of it or whatever. Yes, I signed in here, I took this training, whatever. So you can do 4 at a time. You do have to click yes to continue, certifying that you did do the training, that you did in fact do the training. It's kind of an honor system here. and stuff, but it is pretty important. There have been requests in the not-so-distant past for training records for a Board of Adjustment in an open records request for a legal action.
If I read you correctly, on that listing a couple of slides back of all those classes or videos or whatever, if we review any of those, then we can submit this form, and that would add to our continued education.
That's correct.
Okay.
That's correct. And there's a lot of different things to choose from on there. There really is. I mean, there's everything from housing to, I think there's electric cars and, the whole new electric car thing that's going on. So there's a lot of different things.
When I first started talking with you on the phone, you directed me over to that one, so that's why I was asking. So
Yeah.
You mean I can give myself some credit?
Yes, absolutely. And then also, we still have on the far right, we still have the downloadable PDF form. You have to print it off, fill it out, scan it, upload it, email it back to me. So whichever, we'll still take both, it's fine. But the electronic submission form is pretty easy. I usually turn those around within 1 or 2 days, depending on when I get them. And I'll send you a report back and tell you, here's your updated report, you need this many hours, or, you're current until whatever year. So I think that's it for me. Andy, it's your turn.
Correct me if I'm wrong, but for tonight's training, they don't need to submit anything.
No, you don't need to submit
Because-
anything for tonight.
We know you're here, we can go back and just
Yeah.
include it.
So once I have the
Bonus.
total time for our presentations and stuff, when I get back to the office in the morning, I'll update each of your sheets and send you new ones for tonight's training. Do you need this?
Nope, I'm good. Thank you very much, Pamela. So for the record, my name is Andy Vidakovich with staff. I am the planning manager with PDS, so I'm in charge of basically the day-to-day operations and workloads of all of the planners. You'll see me at meetings, but as you know from previous meetings, you might also see some other members of my staff as well. So Pamela covered the kind of like the administrative role side of things. I'm going to go through more of like the meeting or like what the board actually is authorized to do, what we do as staff, how to make motions and things of that nature. So yeah, so just that's what we're going to be talking about. So if you've been on the board for a length of time, you know that there are 4 key issues that the board has the authority to hear and decide. Variances are very common, probably get those on a monthly basis. Conditional uses are also fairly common as well. Appeals of an administrative decision, and then changes from one nonconforming use to another nonconforming use. And I'll go into each of these a little bit more. So starting off with variances, a lot of times people will come and say they're asking for a variance because that's the word that they're familiar with. But a variance is actually a very specifically defined term within KRS, and not everything that someone needs or asks for is actually technically a variance. So the definition within KRS 100 is up there. It's a departure from a dimensional term of the zoning regulations pertaining to the height, width, length, location of structures, sides of yards and open spaces. So things that qualify for variances are things like setbacks, heights, areas, area or size of signs, things that have a dimension component tied to them. Things that don't necessarily qualify for a variance are things like the number of off-street parking spaces and the number of signs. So while there is a numerical component to those regulations, they're not actually a dimensional term of the zoning ordinance. You're required to have, 10 spaces per every 500 square feet of area. Again, it's not a dimensional term of the zoning ordinance. So again, that can get pretty confusing, and I know to the layperson, the differences may not matter very much, but for the board's part, for our part, those differences are important because the review criteria, depending on what it actually is going to make a difference. So the KRS has quite a bit to say about what needs to be found or considered when taking action on variances. So again, this is one of those parts of the KRS where it's broken up into a couple of different things. They've got findings, but then they've also got considerations, and they're not one and the same. So the first thing, I'm actually going to kind of flip this. I'm going to go over the considerations first, because it says, in making your findings, the board shall consider whether, and then it goes through whether there's a special circumstance, strict application, and the circumstances are the result of actions taken by the applicant. So again, those are considerations, things that the board should, well, basically consider in making your recommendation or decision. And when we go to the staff reports, staff is going to give you our findings on these as well. We're going to give you what we find in our analysis for these considerations. So then the findings, I think this is where basically the rubber meets the road, and when you approve something, these are what you actually must find, is that it will not adversely affect the public health, safety, welfare, alter the essential character, cause a hazard or nuisance, and allow an unreasonable circumvention. So ideally, when you're going through these considerations, you know, it's good to find that at least one or two of these apply to the situation, but we've had instances where none of these have applied, where there hasn't been a special circumstance, where so the strict application is not depriving the applicant, but we still come out at the end saying that granting this variance will not have an adverse effect on the public health, safety, welfare. So does that sort of make sense, the difference between what the considerations are versus what your findings actually have to be? So again, when we're going to recommend, especially in favor of a variance, we're going to look really hard for it and at least see if some of those considerations apply, just because that's the guidance that KRS gives us. But on rare occasions, we'll say no, but yeah, you know, this variance isn't going to adversely affect anybody or alter the essential character, so we are still recommending favorable on it. The other part of KRS 100 states that the board shall deny any request that arises for a variance that arises from the willful violation of the zoning regulations. So basically, somebody goes out and does something, gets cited for it, or says they need a permit, and they put it, say, a fence up in an area that wasn't allowed. You know, and they have to come to the board and seek a variance. Well, again, I think the key there is willful, and sometimes we get into these discussions with boards as like, what is a willful violation? You know, like someone coming in saying, I didn't know that there was a requirement for this, happens quite often. In fact, that's, I think, a lot of what most everybody's argument is. It doesn't, for staff, like, it doesn't matter if you knew or didn't know, like, you know, generally speaking, we're in an area that requires permits, and I kind of look at the analogy of like getting a speeding ticket. You can tell the police officer, well, you didn't know the speed limit was 55. You're still going to get that ticket because you were going 80 miles per hour, for instance. So anyway, we like to say, you know, ignorance isn't an excuse, but it can get you know, kind of convoluted and sometimes. So, but just so you know, that's the way we would always look at something like that. Also with variances, the board may impose any reasonable conditions or restrictions on a variance that you decide to grant. Again, that wording is pretty important, reasonable conditions or restrictions. I think that any condition that you would place on it has to be related somehow to the request. You know, you can't go and require, you know, something that's not related at all to a setback variance, for instance. I think you might end up, potentially opening yourself up to some issues down the road. So, but as long as there's like a reasonable connection to what they're asking for and the condition that you're placing on it, you're allowed to do that. And in terms of the types of conditions, they are, conditions, possible conditions are so case specific, it's hard to like stand before you at a meeting and say like, well, these could be possible conditions you can consider, because until we hear all of the evidence, we're not really going to know like what the specifics of this case are and what conditions might be necessary. I would say that, again, as long as they are reasonable conditions that are tied to the request, your ability to impose those is pretty broad. But again, it has to be something related to the request. Yes?
As an example, we had one in, I believe it was the above, and the board would consider putting a restriction of a geotech. Open the garage. So,
Right.
I mean, that's a little unreasonable.
Right. So again, it's absolutely just going to be a case-by-case scenario, and you don't have to apply or recommend any conditions. That's also an option as well. So you've seen our staff reports before, and I'll go through the staff reports itself in a little bit more detail, but for any one of these issues, our staff report's always going to follow the same general format. We're going to tell you what the statutes say, and for the variances, we're going to go through each one of the considerations that we discussed, and we're going to give you what our findings are on that, and you're welcome to agree or disagree with those. And then we're going to give you a recommendation and the findings. You'll notice that most of our text is going to be up under the consideration, because your findings are literally just very simply what is out of KRS 100. It will not adversely affect the public health, safety, or welfare. Everything that we do to support that recommendation is really before we get to that recommendation. So conditional uses, again, are very common, probably the second most common thing that the board will hear and decide. So there is, again, a very specific use or a very specific definition, a use which is essential to or would promote the public health, safety, welfare, but which would impair the integrity of the zone it's located in, unless restrictions on its location, size, and extent are imposed in addition to those by the regulations. So conditional uses, here in Kentucky, conditional uses are always listed as a conditional use within the zoning ordinance. Somebody can't come in and ask for a conditional use if it's not specifically listed there. So you're always going to have your permitted uses and your conditional uses. And some common examples are churches, funeral homes in residential zones, daycares in residential zones, things like that, again, that you might expect to find in a residential zone, but also are more intense than your typical single-family residential dwelling. So, but there's other conditional uses too. There's conditional uses in commercial zones, industrial zones, things like that. So KRS says that the board may approve, modify, or deny any application. If you approve an application, you may attach conditions. And here under the conditional use statutes, it gets a little bit more specific. But again, I think it is relatively still the same guidance as with the variances. Time limitations, requirements that something be done, conditions of a continuing nature. So time limits, I think that's pretty self-explanatory. Somebody's coming in and they want to do outdoor dining, and without a condition, they could go all night. Well, you can put a time limit on that. Conditions that one more thing be done, again, depending on each case, It could be something like extra screening or landscaping, or maybe a fence, something of that nature. Conditions of a continuous nature, nothing really comes to mind of what that might be, but anyway, it's there as an option. But again, I think that the general rule of thumb is as long as it's reasonably related to the request, and it is necessary to properly integrate that use into the community, then I think you have the latitude to impose those conditions. Same thing with our staff report. You're going to get what the statutes say, what our recommendation is, and then our findings. And again, you'll see our findings are very just straightforward. The conditional use will provide a service that is desirable and will not be detrimental to the general public. Appeals are a bit of a different animal. The board does have the authority to hear and decide appeals. Basically, any person or entity that's claiming to be injuriously aggrieved or affected by any action that staff takes is entitled to file an appeal. And they can file an appeal if they claim that there is an error in any order, judgment, requirement, decision, or refusal made by an administrative official. So some examples that you've seen are the number of signs. Remember, I kind of talked about that before. That's not actually a variance. The way that somebody would get that in front of the board is as an appeal. So number of signs, number of off-street parking spaces, those would all be appeals. So KRS 100 doesn't specify findings necessary for upholding or overturning a decision. However, if you go back to the statutes where it says that there is an error in any order, requirement, decision, so, if at least staff finds or feels that it's inferred in state statutes that the standard there is that there was an error in that decision made by the zoning official.
Can I interrupt you real quick?
Yeah.
So we do have quite a few applicants with an appeal request for a number of signs. That was the one we had last month as well. And what we're deciding on, or what we're considering, is not do we agree that, yeah, it would look nice with more signs or bigger signs, but our decision is actually based upon, did the administrator make an error in their decision per their guidelines that they abide by, correct?
Right. That is correct.
Okay.
And sometimes people will appeal seemingly black and white things, and we'll advise them in the pre-application meeting, like, look, the board is going to have to hear and decide whether there was an error. It's pretty straightforward, but like everybody's got the opportunity to appeal, like regardless of how straightforward something may seem. And sometimes things that seem straightforward, like the number of signs, ends up not being straightforward. The last couple of months, there was an appeal, again, on a number of signs, where you had, I don't know if it was the Jimmy John's or not, but it was along the main road, but then it also had an access drive and some parking around it, and so the ordinance says, one per street frontage. And so we're taking the literal interpretation, well, there's one street frontage here, but it could be that, maybe that access drive, it might not technically be a street, but it functions as a street because it's open to the public, it's not for parking. So again, there's not a whole lot of guidance in statutes regarding like what you can and can't do for finding and overturning. But again, it just is a case-by-case basis. It's a case-by-case basis. Sometimes things, again, might seem pretty black and white, but then when you actually look at the case itself and like, yeah, like that really doesn't apply here. The other thing another good maybe an example is off-street parking required for a use. We might say, well, because of X, Y, and Z, you're considered a retail use, and you are required to provide this much spaces, and they disagree with it, they want fewer spaces, they come to the board and they say, well, because, like, we're really technically this type of use, and therefore, we only required this many parking spaces. Again, you're talking about two black and white, like, text in the code, but there is maybe perhaps some ambiguity based on the nature of the case and which one should actually apply.
If I could just chime in and say, I think you're treading in dangerous ground if you start seeing any ordinances that are up on appeal that seem pretty black and white, that just, at least maybe to you, don't make sense, but per the language, you go ahead and decide, okay, it doesn't make sense, I'm just going to go ahead and overturn it. I think that you're going to make yourself be on some uneasy ground when the next time comes and it's really close and you go the other way on it. You might find yourself setting a poor precedent previously that could be used against you later. And that's why I encourage a lot of boards, I look at the person and go, okay, I see what you're saying here, go to your council members. They're the ones who decide what the ordinance language is going to be and what that administrator is going to be enforcing. We don't make the rules here, we merely enforce whether there was in fact a violation or not. Hope that's helpful.
Yeah, no, and I want to make the distinction between, like you could disagree with the regulation itself. Maybe the regulation itself is just doesn't make sense or isn't, but that's not what, I think, as Sebastian said, that's not what you're here to decide. You're just here to decide whether or not there was an error in the application of that regulation. It's up to the elected officials to actually set the policy. So sometimes those types of things do come up at the meetings, and it can be hard sometimes to kind of separate, personal feelings about it versus what you can and can't actually look at. The other thing, and it especially comes up with appeals, is your motions and action on appeals. I'll touch on this just a little bit because it can just be kind of confusing. So if the motion is to uphold the zoning administrator's decision, then if you vote yes, you are agreeing with that decision. If you vote no, you are disagreeing. If the motion is to overturn the zoning administrator's decision, then a yes vote is that you are disagreeing with the zoning administrator's interpretation, and whereas no is agreeing. So it can just be kind of confusing. You really have to pay attention to what the motion is and what your yes and no vote are actually going to mean. So if somebody makes a motion to overturn the zoning administrator's decision, their vote is going to be yes on that motion because they're the ones who made the motion and agree with the motion. I mean, you don't always need to agree with your own motion, but it's really highly irregular. Anyway, that's a whole separate thing. So anyway, I think it's important to just take your time. I think it's also good for, after there's a motion and a second, for the chairman to reiterate what the motion is and say, so a vote of yes is, is in favor of this or is not in favor of this. So kind of in simpler terms, it's a little bit more clear, not only for the folks out here, but also for your board members. Again, similar with all of the other ones, you're going to see what the statutes are, what the recommendation is, and what our findings will be. Changes from one non-conforming use to another non-conforming use. This is probably the least common issue that comes before any board. But basically what statute says is that certainly if a use has been there for since before the current zoning regulations have been in place, it's a non-conforming use. It's been legally established, that's important, but it's a non-conforming use. And then it says the board, I'll kind of paraphrase this, the board can permit a change from one non-conforming use to another if the new non-conforming use is in the same or more restrictive classification. So someone has, I don't know where the situation may be, but a restaurant in a residential zone, and it's been there forever, pillar of the community. I mean, you probably could think of instances where that is the case, like, but anyway, they want to come in and convert it into an office. well, it's a single-family zone, it's certainly not a single-family use, but they can go through this process and potentially change that use. So I've got a couple of other examples there, daycare to multifamily in a single-family zone. That's actually a case we had over in Crescent Springs, mixed-use buildings to a single-family residence in a commercial zone. So that's an issue that we had over in Kenton County. So what does it mean then by the new nonconforming use is in the same or more restrictive classification? So statutes don't really say what that means. However, your local zoning ordinance does give some guidance regarding that. Basically, what that means per the zoning ordinance is that the new use will generate less traffic, that the new use will emit less noise and air pollution, and that the new use will be a couple things here: more in character with the existing neighborhood, more in conformance with the comprehensive plan, more in conformance with the permitted uses within the zone. So that is I guess the standards that we will be reviewing as staff as to whether or not a new use is in the same or more restrictive classification. And this gets pretty long, but again, you see our staff report and how we will clearly lay out what the state and local statutes are, our considerations, recommendation, and finding. So are there any questions before I go and move on to some other responsibilities of the board? Okay. So addition or responsibilities of the board. Basically, what we ask of you, or what I think what is good, good in terms of good practice for being a board member is, Pamela talked about, we're going to be sending you materials a week before the meeting. Certainly, if you have the time, and we know that it's not always the most exciting thing, and people have lives, but if you do have a chance to review the materials before the meeting, that'll just help kind of sort of get you in the frame of mind. If there's something that is not clear, you make a note of it and ask questions about it, but it ends up just helping you prepare for the meeting. You are certainly encouraged and really should ask questions at the public hearing. You should ask staff questions, applicants questions, public questions. Of course, if there are none, you don't have to make anything up, but it's important that you build a record of your case, because at the end of it all, again, you're going to be making taking action on it based on the evidence that's been presented to you. So, that is technically your record then, is what you've asked, people who've appeared before you, what you've asked them questions on, in addition to the staff report. Have an open discussion that everyone can hear. Not so much a problem with this board, but I have seen boards, they conclude all of their public hearing and then they'll go and form a huddle in the back and have their discussion about it. That's really not a good thing to do. Even when the public hearing is closed and you're having just discussion about things that you've heard or your feelings on it, that should all be open for everyone to hear. The other thing, and this doesn't happen very often, is conducting site visits. So first of all, it is optional, and I want to stress that really before the meeting, you should not conduct a site visit on your own for the purposes of gathering evidence for an issue. Obviously, you live in this community, you drive by these places on a daily basis, you might even go and visit the store, or whatever the case may be. That's unavoidable, but actually going out and conducting your own investigation, you should refrain from doing that. If there is determined to be a need for a site visit, that should only be done during the public hearing. And again, it doesn't happen very often because basically what you need to do is you'll need to recess the public hearing, all of the board members and any of the public that are present travel out to the site, and then everyone has to be able to observe and hear the conversations that the board members are having, and then that's it. And then on the way back, no more discussion, and then reconvene the public hearing and continue your conversation here. In 18 years, we've only had one board ever do that, and they actually had to set up a special meeting to do that just because people weren't prepared to actually go out and visit the site. So they're like, we're going to recess this. We'll come back on this date, conduct our site visit, and make our continue the public hearing after that. So again, it is there. What we'll try to do as staff, though, and what you've seen is that we'll actually go out and visit the site and take pictures of it. So we can at least show you what we observed on it, and we are obviously happy to flip back and forth and show you the stuff. But again, there could be a critical issue or something where you just need to go out and physically look at it yourself to get the idea of what the case is, and we'll certainly help you do that. Do
you mind if I chime in?
Yes.
A running theme you've probably picked up on is everything as far as discussion goes regarding evidence, consideration needs to be done within the public meeting setting on the record. I appreciate that sometimes you just want to talk to the person next to you and talk things out and get things done, but it's opening yourselves up to having future litigation on the more testy ones. Not every single case is going to be, subject to litigation, but that's where my mind goes. I want to warn you all, really be mindful of your discussions between one another. Even the car ride back from a site visit when you're not officially on the record is a time you want to be mindful of that. So, sorry to be the litigator, just have to,
So
big warnings.
I've heard the suggestion, like, if you want to go out and visit a site, get a big van so everybody can sit in the van. Of course, again, that's not something you might be prepared for that night, and you can't do that. I think with the Kenton County one, we took a couple of like the larger cars and everybody was able to fit in that. We had the attorney in one, staff in the other to make sure, nothing was being discussed. So anyway, making motions. So you've heard all the evidence, you've asked your questions, you've discussed amongst yourself. Now somebody wants to make a motion or the chair calls for a motion. So really with just about any one of these issues, you're going to have three choices. You can approve it, you can approve it with conditions, or you can deny it. Regardless of what way you go, your motion is going to follow the same general format. So I've got an example up here, and I think we've printed some out for you as well. And when we actually get to the meetings, we also provide you with some sample motions. But anyway, the basic motion is going to have regardless of what you're doing, approving, denying conditions, is going to kind of follow this format. First of all, you're going to state the case number and what the issue is. So with reference to BOA whatever, variance request for this, that's the way you're going to start off your motion. Then you're going to actually state what you want to do. I move to approve, I move to deny, I move to approve with conditions, the variances, and then after that you're going to state your reasoning for that. So based on the facts and contained in the staff report, this is for something in favor. So based on testimony at the presented by staff and the witnesses at the public hearing. If you're going to do conditions, again, it's not always necessary, but if you're going to do the conditions, then you want to state those, subject to the condition that, the applicant, doesn't have outdoor speakers, whatever the case may be, but state those out very clearly. And then your statutory findings, and that you find that the variance in this case will not adversely affect the public health, safety, welfare. This seems like a very long thing to do, and you're going to feel the spotlights on you as you're going through this, because you're going to be, like, again, it's going to take a while to just kind of muddle through this. But again, it's very important because, again, you're building that record. You know, if anybody 20 years from now has to go back and take a look at why something was done, all they're going to have is, again, the minutes to the meeting, you know, maybe some exhibits and things like that. So, again, I think it can feel laborious, but it's an important part of the process. Yes?
I just had to know if you wanted to touch on, like, the considerations, they're not things that are addressed in the permitting phase.
Right.
Considerations, like you were saying, you know, something like, you know, you can't have speakers, you can't have lights flaring in the back of the property after 10 o'clock, you know, like that.
Right.
But it can't be something that's addressed at the permitting phase.
Right. If you make a motion, and let's say somebody doesn't second it, you know, you can amend your motion, somebody can ask you to amend your motion. It gets into a lot of like meeting procedures, but just generally speaking, as long as there's like a flow and an order to how you're making your motion is going to be important. Again, doesn't happen very often, but it happened just recently where, like, even if you make a motion, say, in favor of a variance, you don't have to vote in favor of that just because you made the motion. I think it was with the planning commission issue, no one was making a motion, so somebody's just like, well, you know, just to get something on the table, they made a motion in favor of it, but then they voted against their own motion. So that's very rare and kind of a strange thing, but just know that sometimes, because you only have like 3 folks here, and, you know, if somebody makes a motion and it's not approved, there's not that many other folks who can make a motion maybe. So it could happen when you have a smaller board.
So if a motion wasn't seconded, you know, I encourage them to amend the motion. And even if it, let's say it just goes on and it's not seconded, does it just, what do you call it? Does it just die? Is it just?
Yeah, I think that I don't know if it's technically the technical legal word, but yeah. It's
Yeah, I'm
not
looking for the
seconded,
technical term to say the motion is.
Dies.
The motion dies for
Motion is dead.
lack of a second.
And then the motion expires.
Okay.
Be a nicer way to put it.
And it's always majority, the majority passes or whatever the motion is, the majority rules. If there was 4 of us and there's a 2-2 tie,
Yep, it's a 2-2 tie then.
then what happens in the tie?
What does happen? Can they take another?
I'd probably call it back for another vote, and I'd like to clarify with Jack on this, but I'm pretty sure it does not pass if it's a deadlock half-half.
Yeah.
But I would want to check in with Jack on that.
I think a little bit of a different issue, but we had a cell tower issue in Kenton County where it was a tie vote. Like, doesn't pass, doesn't fail. I mean, therefore, there was no action to approve it, so or deny it, I should say. I think the motion was to deny it. No motion to deny it, so it was approved. Anyway, those are unique situations, and I mean, we'll be ready to address those, I think, but hopefully, you know, they won't ever really come up. So also remember on the motions, and this kind of goes back to what we were saying with the motion on appeals. So when you're voting yes or no, you're voting on the motion, you're not voting on the request. So if the motion is to deny something, your yes vote is to deny the request, you know? So, and again, sometimes that can be confusing, and that's why I think as the chairman, it's good to sort of clarify, you know, the motion is to deny this request, so therefore a yes vote is to vote no on the issue. And it can be confusing even for the folks out there, you know, they can be left kind of wondering what happened. So just keep that in mind. Communicating with staff, we are here to serve you, and certainly it's important for us to have a relationship where we talk with each other. There are some things, though, that are probably less appropriate to discuss with staff and hold for the meeting. However, there is stuff that you can discuss with us. Certainly at any point in time when there are no issues before us, you can contact us and we'll be happy to talk to you about something that you have a question on. I think importantly, and Pamela touched on this earlier, is please respond to the hearing invitation so we know whether or not there's going to be a quorum or not. If there's not a quorum, obviously, then we'll have to work on our ends to set something up.
So with a board of 5, what's a quorum, 3?
3. You can certainly contact a planner for general clarifications. You get the staff report, and it does happen. We make errors and typos in our reports sometimes, and you see something like that, it doesn't make sense for whatever reason, you can certainly contact us and we will clarify it. And in fact, we would probably appreciate it because then when we get to the public hearing, we can clarify that for everyone else. If you have any questions regarding how a public hearing should be handled, again, that's something that you can contact us about. If you have any questions about your continuing education, you can contact Pamela. And again, any general questions and support, you're welcome to call us. I think where it might get dicey is if you call and you start asking us questions about, like, well, couldn't the applicant do this or do that? Or, those types of questions, like specifically regarding the case, are, in my opinion, more appropriate for the public hearing because, well, first of all, in that particular case, we can't speak for the applicant, but secondly, so everybody can hear the question and hear the response to that question, because that's more of a fact-finding question than it is just a general clarification question. I think that's where I was going with that. Finally, any legal concerns? You do have an attorney, Jack or Brandon or Sebastian, I think would be happy to address those. You're not up here all on your own. So any concerns like that, you can address to your attorney. I don't know if they can contact, or if you can contact the attorneys directly, but I would just recommend contacting Peter or Sherry, and then they will help you get in touch that way. Communicating at meetings. So first of all, Sebastian touched on it. Try to only have one conversation going at a time, because again, sometimes even just whispering on the side here can distract from a conversation that's going on. These microphones are doing a fantastic job of picking up all the noise, so it doesn't take much before it might become overwhelming. When you have a question or a comment, you should formally address the chair. Mr. Chairman, I have a question. Okay, go ahead. Or Mr. Chairman, I'd like to make a motion. That's just kind of more of like the formality of the public hearing. Anyone who wants to address the board, is really important for them to come to the podium so that their comments can be picked up and recorded for the record. Obviously, they should state their name and address and be sworn in by the chair or other designated person.
I got a question for that.
Yeah.
So their name, obviously their individual name, their home address, or if they're speaking on behalf of a company or an entity, the corporate name
Yes.
and address is what we're looking for.
Yes, I think that's perfectly fine. If someone, like, you'll get an engineer who comes up here, they're not going to give their home address, they're going to give the address of their company. So yes, I think that's fine. Presentations or documents provided by the applicant, basically by anybody, may be accepted by evidence and by the board and marked as exhibits. Sometimes you will have someone come and give a PowerPoint presentation. We will do our best before the meeting to get a copy of that, so we have it for the record, but if we don't get a copy of it, it's important to either have it downloaded so you can make a copy of it later, or somehow have a record of that.
So they can, if they let's say, have a PowerPoint, you aren't aware, we're not aware, and they want to present it, they're allowed to present it, and just make it clear to them that they have to provide us a copy to enter formally into the record.
Right.
Okay.
And I think most of the time, someone who's coming with a presentation will contact staff to make sure, like, what, and so then at that point, we'll say, well, send it to us, and we'll make sure it's on there, and then we have a copy of it, or at least bring up one printout to submit for the record, that kind of
I
thing.
just want to make sure that if in case they don't bring a copy, that they still can present it, and we'll
Right.
just follow up with them to get it.
Right. Some of the other weird things that we've gotten, we had somebody want to try to submit a video off of her phone, and they were like, well, you need to download that to a flash drive. She couldn't figure out how to download it to a flash drive. Like, you can't just stand there and show us a video of it, because unless you want to give us your phone or download like all the information on your phone, which, I mean, again, it happened, but.
So do I permit that video on their phone to show, or do I just shut it down and say?
I think you have to shut that down, honestly, because if they're not willing to submit something for the record,
Right.
so,
I think it was just noted in the minutes, it was in a planning commission.
right.
I think, yeah, I've seen that with a proponent or an opponent, usually not the applicant themselves, because they are, to your point, a little more structured,
Yeah.
but somebody who's passionate, coming in from the public and wants to show a video they
Yeah.
took on their phone, I could see that happening.
Right. Yeah, it's a little unfortunate if they come to the meeting and they just don't know and are not prepared, but with this particular individual, like, we told her before the meeting, you need to make sure you have this in a format where we can, anyway. The other thing that we've had is somebody, printing off Facebook comments, stuff like that. Again, I would say, like, that's not stuff that you could really accept. Of course, that's sort of a legal question, but again, you don't really know who those people are. There's no ability to cross-examine those people in the public hearing. It could be folks from Florida, for all we know, so.
It'd be hearsay too.
Yeah, exactly.
And I'll say on the flip side of that, if you do accept it, you all always get to decide the weight of the credibility of whatever evidence is put before you. So you could always say, okay, great, thank you. They go into the record and, you find your basis based on anything else. I'll say, though, whatever you end up deciding to do when it comes to, say, that person who comes in with the video, if you decide to turn that person away, I just want to stress to you that in future instances where a person brings a video, you need to have a hard line. Same thing with people. There are going to be people who want to show you photos on their phone. You need to take a real hard line stance from then on, because what I don't want to see happen to you all is, that one issue blow up where you turn that one away and then they can go back into previous findings where you did accept it. That's where things start to get hairy.
Yeah.
So I just want to stress being consistent.
What is your formal legal opinion on that?
Personally, I don't really mind them playing the video for all members to watch, and again, you get to weigh it into your credibility, because I know at some point you're going to have someone show up with a photo and go, hey, look at it, and you all are going to be able to pass it along real quick, and it's going to be a no big deal situation. So that's kind of how I feel. I'd be interested to see if Jack has a different feeling on that, but I would say that's how most of my cities would handle it. I can appreciate the hard line of, well, you need to be able to hand it over to us in a USB. My gut says that if you are going to have that hard line that you need to be able to provide it over fully, then somewhere on a website that needs to be placed ahead of time, and that hard line needs to be followed consistently in the future.
Right. No, and I appreciate that. And obviously, your legal counsel, they're the ones who are there to help you out and keep you out of court, but also to defend you if you end up in court. So, yeah, I would.
This is not the norm, right? Most of these do not result in major litigation. You do not need to resign out of being afraid to be dragged into things. But again, I'm the litigator, so I'm here to make the hair stick up.
I would say for the most part, again, from my experience with the Planning Commission, they do give a great deal of latitude to folks in terms of like what they're saying. It might be completely off the topic, but as long as they're not standing up there for a half an hour and really just taking up time, it's better just to let them like finish and do what they want to say, in order to just avoid anybody coming back to you at a later point and saying like, well, they didn't let me say what I wanted to say. Like, it might be an extra 5 minutes, but.
So speaking of, if there was a contentious topic and there was a lot of people here that wanted to speak, is there a time limit that we could predetermine and just say, hey, guys, you got 5 minutes apiece, 10 minutes apiece, or is there anything written, in a statute or?
Not in the statute. That would be part of your bylaws, and I'm not familiar with those. Again, the boards and the planning commission that do have it in their bylaws, it's rarely enforced because, again, it's like, okay, like they're going 6 minutes. Like, it's better to just let them go and finish their thought. But I know what you're saying. Like, again, I would just say, like, let folks say what they need to say. It is going to come down maybe a little bit to meeting management, like after like the 20th time you've heard somebody say something, it might be good to say, does anybody else have anything else new to say that we haven't heard? Just, and then keep reiterating that. And of course, they'll still probably get up and say something anyway, but.
So one thing that we did on the planning commission was when you get the sign-in sheet, right? So if you want to speak, you have to be on the sign-in sheet. So I'm going to confirm that. If there's anybody else that hasn't signed in, if you're not on here, you can't speak. Read off their names and identify who are proponents, who are opponents, and go in that order. The applicant, the proponents, the opponents, correct? Is that the same format we should follow here?
Yep, opponents and then neutral parties at the end.
Neutral parties. And then after that, does the applicant have a chance to then address any of the comments that have been had? It's not written down from what I see, but I thought I'd ask.
Yeah, I think they should be given an opportunity to address any comments or questions. Actually, that kind of brings up my next point here is, so sometimes, maybe even a lot of times, you'll actually sort of get this conversation going between somebody that's addressing the board and the applicant, like, well, what's this or what's that, and again, it doesn't pick everything up for the record. It's hard to hear that sometimes. What I recommend is that if someone comes up, because they're not going to know, they're going to be like, well, does the applicant plan on doing this? That's when the board, and in particular you, Mr. Chairman, can say, we'll make a note of that question and we'll ask the applicant to come up and address it at the end of everything. And ask them, like, do you have any other questions, to just avoid that back and forth banter out there.
Yeah, I know that whether you're proponent, opponent, or neutral, it's, this is your one and only time to talk. Speak now, forever hold your peace. There's no back and forth that they get to have.
Right.
But yeah, usually when the applicant comes back up and then addresses the questions, they want to engage in a dialogue, and I'm going to.
Right.
My role, my responsibility is to not allow that to happen.
Right. So again, yeah, it's just, again, natural. I mean, they're here. They've probably never been to a public hearing before. They have questions. They want to just turn and ask, the applicant the questions directly. So, but address them to the board, make a note of it, have, 20 other people come up, make a note of whatever their comments are or questions are, and then the applicant come up and address those all at once. Finally, so after you've heard all of the testimony and you're having your board discussion, that's the time when no further comments from the public are being accepted. So again, your discussion is going to be open for everyone to hear. So you might say something and someone might be like, like that's not correct or whatever. Like that time has passed. Now, you can have your discussion, and I think anyway that you can ask for clarification from the applicant or a particular individual, but the time for like general comments from the public is over, and the only time someone can really have any additional testimonies if you ask for that additional clarification.
Okay, so we can bring somebody up if there's a specific person we wanted a clarification on, whether they're the applicant, someone from staff, or opponent, proponent. We can do that.
That's what I think. I don't know if you have an opinion on that.
Your staff's there to assist you with the questions regarding the application process. They've got a recommendation, and they're going to back that recommendation up or make statements as to why they made that verification. So you absolutely can pulled them up and asked for a point of clarification.
So I'm going to try to wrap this up. I see we've gotten you at least an hour of continuing ed, and we don't want to make that 2 hours, so. No, but honestly, I'm happy that we have this opportunity to kind of have this discussion. So our staff reports, you've seen several of them. They're going to follow the same general format regardless of the issue. So we're going to go over the general case information, give you some background. Then we'll do our analysis where we look at the current zoning and land use submittals. We'll review the site plan with you, and we'll review the relevant sections of the code, and then we'll get to the statutes, the recommendations, and the basis, which you've seen earlier. Sometimes, well, it seems like it happens pretty often, is where there's actually multiple requests. And so things can get a little bit hairy in that regard. But again, I think the thing for you to remember is that the first part of our staff report is always going to be the same regardless of how many requests there are. We're always going to give you the general case information. We're always going to give you the background on the request. And then we're always going to do our analysis. And we're going to look at the current zoning and the land use and other things. Once we do those first 4 parts, then we're going to break it up into the separate requests as necessary. So request 1 is a variance. This is what the site plan shows. This is the relevant sections. And then we're going to give you an individual recommendation and basis for just that variance. And then we're going to move on to the next one. The next one is conditional use. And we're going to go through the whole thing again, and then the whole thing again. That's how we're going to structure it on our staff report. So in writing, it's going to be hopefully pretty straightforward. Sometimes it makes sense, like when we're giving our presentations, to lump some of these requests together. And so we might end up doing that, and we'll just make sure that we're being very clear with you on, this is for request 1 and 2, and go through it that way. Again, that just, sometimes, something that makes sense in writing doesn't always translate over into a presentation and come across as being completely logical or making sense. So again, but we'll do our best to walk you and the folks here through those presentations. Also, when there are multiple requests, sometimes you will have independent requests, such as someone wants to ask for a variance for the height of the sign and also the setback of the sign, and oh yeah, they need a building setback too. Each one of those is basically independent of the other ones. So you can deny the height of the sign, you can grant the building setback, and you can grant the setback for the sign. Each one of those requests really requires a motion and an action. And I would recommend doing separate motions on all of the requests. Again, I know it can be a little tedious to go through it. It is entirely up to you, again, based on the complexity of the issue. If you feel like you want to recommend favorable on multiple requests, just make sure you state that up front as you're going through your motions. Request 1 is this, request 2 is this. But again, I think really for clarity's sakes, it's better just to do, even if it's like all approval and your findings are the same for every request, it's better just to do it separately so it's clear. Sometimes you will have a dependent request where really the second request depends on whatever your action is on the first request. So I was trying to think of an example. The one I came up with was allowing a pole sign where a ground sign is only allowed. And then also a variance to increase the height of a sign. Well, if you deny the pole sign, then the height of the height of the sign is no longer relevant because they're not getting one, they don't need the other. I would still recommend making a motion on both of those requests, though, even though one hinges on the other. Just because you deny one doesn't necessarily make the other one just go away. It's better, even though it is everybody's like, yeah, of course they're going to deny it. It still makes sense to just go through the steps, make the motion, and take action on both of those requests, so we don't have any loose ends out there. Do you have anything else to add?
Put it on the record. It's a public hearing. There are state statutes and regulations regarding the open nature of these proceedings. Keep that in mind also when you may be emailing with staff or another member that said records may be subject to open records requests. Say that there is some sort of litigation that's brewing regarding a decision of this body. Every single one of those emails, text messages may be subject to open records, and I'd like to encourage you before you hit send to think whether you'd be okay with that being read into the public record somewhere. Again, this is a open proceeding, and these things can be sought out through litigation or through open records requests. So I'd just encourage you to be mindful of that. But again, sorry to scare, but it's what I deal with. Hopefully we never get there, guys.
Yeah. Any other questions or thoughts?
Nope, I think we're good. Appreciate it.
Well, again, I would just encourage you, again, and if for whatever reason we've explained something at the public hearing and it's confusing, there's no harm in asking a question about, like, can you explain that again? Or was that part of the request 1, request 2? We'll get it right for you. Don't ever think like, well, that's the presentation, and if I didn't understand something, then that's like my fault for not understanding it. Chances are, if you're not understanding something, then there's other folks that aren't understanding it too, and we should straighten it out. Well, thank you. If there's no other questions, I guess.
I just want to thank you for letting us come.
Yeah, thanks for having us. I know, again, we worked together on the Planning Commission, and PDS has always done an excellent job, and there has been times when I've agreed and disagreed with some of your findings, and but no, you guys have always done an excellent job, so thank you for continuing to do what you do.
Well, and don't ever think like you're going to offend staff by disagreeing with our recommendation. It's just a recommendation to you. We're basing it on the information we had before the public hearing. At the public hearing, you're going to get more information that we didn't necessarily have, and you can make your own findings. And if you need help, making a recommendation or guidance on that, even if it's not the one that we recommended, we'll be happy to help you out with that, because we're all on the same team here.
I did just receive clarification from Jack, by the way. If it is a 2 versus 2 vote, it dies. So, because there's no majority.
Is it subject to, can they reapply again, the applicant, or?
I would imagine yes, but I will ask Jack to clarify that and send an email on
Okay, so, as for that meeting, it's dead, and we just move on with the
Yes.
agenda. I would just like to know that I could let them, hey, if you want to reapply, then you could come back next month or 2 months, or I don't know, there might be a timeline or a waiting period.
Well, what I would say is that from the discussion you're having, hopefully it becomes sort of apparent like where the vote might come down. And it's not always, but if the applicant is ever getting the sense that like, oh, this might end up with a tie, they could always table the issue.
Yeah.
Like, let's wait until we get the tie-breaking vote here.
That's a great point.
So then you don't even have to.
So who can table? Can they request for a table? We can
Any
table.
of you can make a
Request.
motion to table.
Right.
They themselves can make a request that,
Yeah.
and you all would obviously have to concur with that.
So either the applicant or one of the board members can make a motion to table, and then,
They can't decide independent, they can decide to withdraw.
Right.
Altogether. They can't independently decide, next meeting, see ya. You all would have to decide on it being held.
they could ask, and then we vote yes.
Right.
Yeah, okay.
And you can recommend to them, would you consider tabling so there's time to make modification to this?
Is that a simple yay, nay vote, or do we have to do a full roll call?
It would be a simple majority. I'd probably roll call it.
Okay.
Honestly, I'm a big fan of roll calling everything other than pretty much minutes. But
All right. So,
gives you a hard time.
anything else from anybody else? We're all good, so again, to keep it formal and move along. No staff items, audience items. Next meeting, April 22nd. Do we have any applicants yet?
I will help you with that. Yes, you do.
Okay.
And I will send a meeting invitation out in the morning.
Okay.
It is going to be a variance and conditional use for an accessory dwelling unit. So I will send out all the details for that to you all in the morning.
Okay,
Okay?
very good. And with that, we take a motion to adjourn. Any motions?
A motion to adjourn?
Mr. McVeigh?
I second.
Mr. Rolfe? All those in favor? Aye. So adjourned.